Good evening, YouTubers. I hope you're having a wonderful day. It's Tuesday. It's 8 p.m. Eastern Time, our regularly scheduled live stream. Hope everybody's doing well. As you come in, do me a favor and let me know how the audio and video is. We did have a problem a couple of weeks ago, so I just want to make sure before we get started, everything is working well. Just let me know how everything is. If I'm a little unorganized or a little disheveled here, pardon me. I just literally finished here as we're talking, just putting everything together. I'm running a little bit behind schedule. This week has been just about as hectic as I can imagine. So a lot of things are just kind of like going a little slower than normal. So pardon me if I don't have everything quite as organized as I like to have it. This is going to be like most of our other live stream. It's all about the communication, you, me. It's all about whether or not you have a question, you want to ask me for a comment, you want to make a comment about what I'm saying, you want to discuss it. But it's all about this, right? Because otherwise this could be just a recorded video. So for that to work, we both have to talk, not just me, you too. So that's what's going to happen through the chat, right? So you've got anything to say, just put it into the chat. But you remember, see this little orange box here? Put an @youtuberlaw in front of your comment. A lot of people are talking. I can't discern from looking at the chat who wants to ask me a question versus who's commenting to anybody else. So when you put @youtuberlaw, that puts an orange box in front of your comment. It tells me to read out your comment. So if there is no @youtuberlaw, I'm not going to read it. It's not personal. I just don't have a way of knowing whether or not it's actually a comment you want me to respond to or not. I'm sorry, I'm still actually setting just stuff up here. I'm trying to get here the comments up and running while we're speaking here. As always, we're basically going to do a quick little check on quick little discussion on the topic that we discussed. Let me just put up the poll that I put on about 24 hours ago. You can see here about the two topics. They pretty much are completely even between the topics. You know, probably should have tried to stack the deck so that one would come out more than the other, but pretty much even. I just chose the one, obviously, that won by a small margin. The first one was about Meghan Murphy suing Twitter for banning her account, basically claiming unconscionability in the way Twitter actually follows or fails to follow its terms of service. Interesting case. Maybe we'll do a recorded video on it. Maybe we'll talk about it next week. But it's interesting because this time the plaintiff is not on the right. It's actually on the left, which makes the whole discussion a little more interesting, although legally it's the same thing. And today's video, which is about the demonetization by YouTube of videos, of comments, of how they handle it, given the fact that they've uncovered the fact that some videos that are otherwise completely appropriate for the platform and completely appropriate for brands to advertise against are somehow having bad comments and their reaction to it. The questions that have come up a number of times is this permissible? Is this legal? Or the more common question, is this unconscionable? I'm going to get into that. So what we're going to do is I'm going to discuss the topic here, probably do a 5-10 minute discussion of the topic. Then I'm going to go back to the comment, really go through and each one of your questions, your comment, anything you want to discuss. So just write them down. So as you go along, you have an idea in mind, just put @youtuberlaw and whatever your comment is. I will get to it once I'm done talking about the subject. Again, 10 minutes. I'll go and I'm going to go one by one. Sometimes the stuff stacks up. I will get to your comment if you want to jump the line, kind of like a Disney or Universal Fast Pass. Do a super chat. Otherwise, I'm just going to go one by one. I think we're good. I think we're good to start. Let's start the stream and we'll go from there. Hello to everybody once again. We're going to start the stream. Let me just go through some of the comments before we actually go any further. Bart Silverstein, hi Lior, glad to have you caught your stream on time for a change. Excellent. I know that for many of you, the stream is in a really awkward time, so I really appreciate you coming. Brian Feriak, Fediuk, I think. Happy Tuesday. Happy Tuesday to you too. Brian Gibson, good evening, Lior. Sounds looks good. Awesome. Cons Clan Sith, hello all. Hit the like button, people. Excellent. Thank you so much. If you can hit the like button, that helps actually promote it while we're talking. Dirk, audio video looks great. Nigel Rhodes, have you added any chat mods yet? Yes. Right now, my wife is moderating the chats, so we're trying it out to see how that works. In generally, don't like to touch the chat too much unless it just becomes too disruptive, so you guys cannot have a conversation. So I'm trying to err on the side of let everybody speak their mind. But when it's not directed at me and it's not a question, and it's just directed at you guys and it's kind of like consumes the entire chat, doesn't allow you guys to speak, that's when somebody should just step in for nothing else, just to accommodate conversation. Nothing much beyond that. Okay, so let's talk about today's subject here. We're going to talk about YouTube's demonetizing videos that include any sort of bad or inappropriate comments. Now, why did that come up? Just a couple of seconds on the topic. This came up in a tweet where a mother asked about videos related to her son. Says she has, my 5-year-old son does gymnastics and is a happy, sweet, confident boy. YouTube not advertiser friendly, and she's showing how all her videos have been demonetized. Obviously, as you can imagine, that is somewhat disturbing when suddenly for no reason your videos are demonetized, to which YouTube responds, hi there, for reference, over the past few days we've taken a number of actions to better protect the YouTube community from content that engenders minors. Here's a tweet from Philly D for more context. That's a very strange response. Here they're making reference to the fact that content may be inappropriate. Apparently that's not really what they meant by it. What they meant for it is, with regards to the action that we've taken, even if your video is suitable for advertisers, inappropriate comment could result in your video receiving limited or no ads, a yellow icon. Let us know if you have any questions. Any questions? In a span of 2 tweets that came one after the other. First you say that video content may be inappropriate. It's a video of a child doing gymnastics. The second one referencing comments. So now that a video can be demonetized based on the content of a comment placed by somebody else. Obviously, that started a whole storm of people having issues with that. And then with reference to whatever they responded to when it came to Philly D, it says, we appreciate you raising awareness of this with your fans and that you realize all of us at YouTube are working incredibly hard to root out horrible behavior on our platform. By way of an update, in the last 48 hours, beyond our normal protections, we've disabled comments on tens of millions of videos. We also terminated over 400 channels for comments left on their videos. So now basically they created an entire world of confusion where at the beginning they're saying we demonetize because content is inappropriate. This is all child-friendly kind of content, made no sense. Second one saying that it's all about the comments when the comments are inappropriate. And the third one saying that we in fact actually removed comments and terminated accounts related to where those comments came from. So that raised the question, is that unconscionable? Specifically about whether or not if you create content, a video that otherwise meets all the guidelines of YouTube, that otherwise is advertiser friendly, meaning the advertisers of no particular issue advertising or placing their advertising against your content, can somebody, by virtue of actually putting a comment that is otherwise objectionable, actually cause your video to actually be either terminated, removed, or more likely here, demonetized? Because that's what it shows from the conversation, that is what YouTube is doing. Now, in all fairness, it's quite possible that this is kind of like an interim solution to a bigger problem. True or not, although one YouTuber pointed out to YouTube and to the greater community that at times the comments themselves are inappropriate. Sometimes they are resembling pedophilia, and maybe YouTube should do about it. And YouTube's response was, as always, kind of a shotgun approach. Let's take let's basically stop monetizing to make sure that none of the advertisers are actually showing against those videos, rather than dealing with the comments detailed with the video. Nonetheless, this seems to be a pattern. If nothing, that YouTube responds first by removing demonetization. At least they didn't remove the video, but only demonetization. Later on went in and started removing comments and removing accounts associated with comments. So the question is that legal? Think about it. You create a video that's appropriate, a third person places a comment, you lose your monetization because of that third person. You have nothing, again, that you have nothing to do with that comment. So how do we look at all of that? What is the issue is? Well, first of all, the question here first deal with unconscionability. For those of you who may not understand, unconscionability basically means if there is a provision in a contract that is otherwise what's called unconscionable, it's so abhorrent to the law that a judge will just not enforce it. Typically, those kind of contract involves the inability for two parties to negotiate specific terms, right? So we negotiate a contract, the other side is more powerful, they put in a clause that otherwise I would never have agreed on. A court may say, you know what, it's just unconscionable because the parties could never have negotiated something like that. We should not actually enforce it. So even though arguably two parties agreed to it, a court may actually come in and remove it. So the question is something like this considered unconscionable? Now, where did we deal with that before? Well, not specifically with the unconscionability, but we dealt with something very specific, very similar a few months ago when YouTube decided that based on the comments in the super chats, they may divert some of the super chats being paid by viewers during a live stream to a charity, or rather than to the actual YouTuber, because there was basically this notion that a lot of people with questionable motives are putting in super chats. A super chat basically puts a highlighter around the comments. Those comments tend to be read out loud by the content creator, the person who's moderating the actual live stream. As a result, it promotes certain comments. The idea being, if those comments may be inappropriate or otherwise violating YouTube's own policy, let's say they're racist or harassing or doxing or something of that nature, that then the creator should not be receiving the money made through the super chat. And we went through that and I explained to you why legally, from a legal perspective, that's not permissible, that YouTube actually cannot divert super chats. And I explained to you by looking at all the contracts, and it gets very complicated, that when it comes to super chat, the relationship is between you, the viewer, and YouTube. It's not actually with the live streamer, the content creator. You are led to believe that it is with a content creator, but in fact, YouTube is just selling you a service, a product, which is a highlight of your comment. And as a result, when you pay, YouTube is asserting ownership of your money and then chooses not to share it with the content creator. And I explain how contractually that cannot work legally because of the agreement between the content creator and YouTube that is based on the idea that the minute YouTube receives money, the content creator is then owed that money. As a result, YouTube is not in a position to take money from you and divert it. It only has the option of either refunding it back to whoever paid it, or giving the creator its share. So we went through that kind of analysis. I'm going to try to do a similar sort of analysis here to explain what the situation here when it comes to YouTube deciding to demonetize a video based on content, or rather comments that were posted by a third party unrelated to the content creator. Now, when you start looking into YouTube, and it was true before and it's true now, there are probably over a dozen different agreements that you have to examine. It's not so clear that, you look at some rules, is it matching the rules or it's in violating of the rules, and as a result, it goes one way or another. There are in fact maybe a dozen different agreements. Not only are there terms of service and privacy policies for YouTube, there are rules, community guidelines that are to be adhered to by everybody, including the content creator and the people that are placing comments. There are various terms of service that are associated with different levels of services that are provided by YouTube, and that's what I had to go through, about a dozen different contracts. as well as various areas where rules are being posted to put together the story of what's actually is happening here. And the one thing that I wanted to figure out, the first thing is, where does it actually say, if anywhere, that you can be demonetized based on comments? And the question, even now, even though this happened a couple of weeks ago, nowhere. I cannot find any place where that. Maybe I missed some place, maybe if you guys find it, but I, for once, could not find any place where within any of the agreements or any of the rules or any of the community kind of policies, there is actually any indication that this is actually taking place, except for those same tweets, those same conversations that were happening on Twitter. Nowhere else is that. Now, is that mean that they can't do it? No, it just means that we have to keep that in mind as we're analyzing to understand what that actually means to the problem. So the first place we look at is AdSense. And what we have is, when you want to monetize your videos, you first have to join the YouTuber Partner Program, and you have to set up an account with AdSense. You have to be approved by both of them, and once those two together, then your videos can be monetized. And when I was looking at AdSense, this is the provision that my eyes focused on. It says, by enrolling in AdSense, you permit Google to serve as applicable advertisements and other content called ads. So take a look at that. What does that actually say? This is your ability to earn money. This is not your general monetization, which takes place through the partner program. This is actually the portion, the brokerage of advertisement that enables you to make money. And it says that you are permitting Google to serve. What doesn't it say? It doesn't give you, and you look anywhere within AdSense, AdSense doesn't guarantee you advertisement. It allows you to give permission to YouTube, to Google, to place advertisements on your video. There's no guarantee of how many advertisements will be. There's no guarantee of how those ads will be priced. We know that they're priced on an auction basis, but there's no guarantee that your advertisement, even if your channel is otherwise you consider to be equal to somebody else, there's no guarantee that they don't make money off of every view than you do. There is no guarantee that you will be provided advertisement 7 days a week, 24 hours a day. There is no guarantee. It's only a permission. You give them permission to place advertisement next to your video. Next, it says in the bottom of that same paragraph, Google may refuse to provide the services to any property. And now, if you start reading through the agreement, what you get is the same thing. This is a brokerage tool, brokerage services. They're acting as a middleman between you and the advertiser, choosing on their own where to place advertisements, or allowing the advertisers to choose one way or another with absolutely no guarantee, and that service may be terminated as far as you are concerned. So you have two things: no guarantee of how many advertisements are placed, and they can terminate your service. We're not talking here about demonetization. We're talking about termination of your AdSense, which effectively terminates your monetization because you are in the program, but they're not allowed to actually make any money. So then if you go to the YouTuber Partner Program, you see this. If you are in the YouTube Partner Program, it's important to follow the YouTube Partner Program policies, which include the community guideline, terms of service, Google AdSense policies. These and everything else you have to add on to. That's fine. Basically, all the other policies, and again, there's maybe a dozen because each one of those connects to additional policies. So it's a never-ending voyage down a hole here. And then it says, if you violate any of those policies, YouTube may take some of or any of the following action, which disabling ads, disabling your AdSense account, suspending your participation in the YouTube Partner Program, suspending or even terminating your YouTube channel. So where does that take us? It means that if you violate any of the partner program, if you violate any of the AdSense program, they can they can terminate your AdSense. If you violate the partner program, they can actually remove you and from the entire program. Not only can they terminate your channel, they can actually demonetize you in part or in whole here. Next, if you take a look at the community guidelines, you realize that, and you've seen the community guidelines many, many times, that in fact YouTube can go after you based on any action you do anywhere. There's lots of rules about what you personally cannot do on the platform, but if you can see, and this was a provision that was added kind of late in the last couple of months, it says if YouTube's creator on and or off platforms behavior harms our users, community, employees, ecosystem, we may respond based on a number of factors, including but not limited to the egregiousness of their action and whether a pattern of harmful behavior exists. Our response will range from suspending a creator's privileges to account termination. What does that mean? It means basically if you violate any of our rules, no matter what, we can terminate you. And obviously, we can demonetize you because ultimately all of these rules and policies are interconnected. And last, there's also a policy dealing with moderation. And the key term here to look at is when moderation are turned on for your video, you can use our tool to moderate the conversation. The key provision here is you can do that. If you search through all that, there is never an obligation. That actually is repeated in some of the tweet messages that YouTube sends out. There is absolutely no obligation on the part of a creator to actually moderate the conversation that's happening on their videos. In fact, the mother who actually was complaining about her son's videos being demonetized, she actually heavily moderates that community, and yet YouTube felt that it's still not appropriate enough, and they still demonetized her videos. So where does that all take us? Well, this is an issue of AdSense. Demonetization. We're not talking about removal of your video, taking down your video. We're not talking about termination or suspension of your account. That would have been handled under YouTube's terms of service and their community guidelines. We're talking about demonetization of a single video that would fall under either the partner program or the AdSense. In this case, we're looking at AdSense, and it clearly states that YouTube is basically a broker that has now permission to place ads but doesn't guarantee. We think of the fact that when we sign up to YouTube, we have a certain guarantee of our videos being monetized. No, what we are signing off is basically having a broker make decisions of where to put advertisements or not, and that the idea that any single video may have expensive ads or cheap ads running 24/7 or just in specific hours, ads that are only applicable depending on who's viewing it, or very limited advertisements or no advertisements at all. That's within the scope of them acting as a broker. But that does not leave everything, because the rules still say that if an advertisement is shown, money is basically being earned. You have to understand that if YouTube decides to place an advertisement next to a video, at that point, the creator legally has earned money. The only time they can withhold it, and that's based on their AdSense policy, is if you broke some policy associated with the partner program or the AdSense. And those policies only make reference to the creator's own action, which does not include moderation. So if an advertisement is actually shown next to a video, YouTube is not permitted to then withhold money that would go toward the content creator. But to the extent to which they decide to limit how much advertisement is showing, or show no advertisement at all, YouTube is permitted to do so, because as their function as a pure broker, they can do that because they are not required to provide you with any advertisement. It's you who are asking them to broker the placement of advertisement, but they're not in any way required to do so. So the question of it's really not a question of unconscionability, because those provisions never actually show up in any of the agreements. This is an issue of whether or not YouTube can actually enforce an internal rule that they've created and they've announced, but have not placed into their rules. If they've actually placed it into their rules, they technically would have been able to actually run advertisements and then punish the creator for comments without giving them money. But the fact that it's, as long as it's not in the actual rules, YouTube is permitted to demonetize videos. However, it sounds disturbing. They are permitted by the agreement to demonetize any single video or make the advertisements available very, very limited. But at that point, it's not allowed to actually keep any of the money associated with it. It basically would have to show no videos, no advertisements at all. So it's one way or another. I'm hoping that that clarified. There's a lot of agreements that are required to be analyzed in order to reach that conclusion. I hope that this is clear. Let me know in the comments below, in the chat, whether or not I missed something. Let's go into the chat and see what's going on. Let's see. Charles de Liberis. I think it's better because a stream would be demonetized for bad. Moderation would be better. It could be. But so far we haven't had those kind of problems. I know that some people have had some interesting conversations on the chat, but so far there have not been the kind of conversation that really have risked anything. So I don't think that moderation of the chat, at least on this channel, has been a big issue so far. Golden Mongoose, hey Lior, hope you're doing well, looking sharp as always. Thank you so much, I appreciate it. The Bacon Wizard, will you talk about enforcement as well as whether that's unconscionable? That's exactly, I hope that that's what I did here. It's not unconscionable, and enforceability is based on whether or not they then choose to run advertising. Because what we've seen before is sometimes when you are not getting paid, they're still running advertisements. It's not as if your video is not monetized and means that there's no videos running. It just means that you are not making any money off of it. They're still entitled sometime to run videos. The issue is in this case is, if they're running ads, 1 or 100, they are required to pay you. If they are not, they are permitted as a broker to actually, what we call in demonetization, for them is just, we're allocating our advertisements across the entire platform. Some are getting more, some are less. As a broker, we're not guaranteeing you any advertisement. So to us, it seems like my video got demonetized, but from their perspective, the way they've organized it, the way they've done it, again, they've done it legally. They're very intelligent. They didn't do it in the sense of any obligation toward the creator. They did it as of, you are just authorizing YouTube to allow them to place, and they can do whatever they want with it. So they don't have to terminate your account, but they can still demonetize it. They can keep your AdSense account, allow you to make money, and yet not place any advertisements on it, or place, let's say, unappealing advertisements that don't pay as much money. So they have a lot of leeway in the way they manage their brokerage firm, which is this AdSense of how videos are actually monetized. The meme of destruction. Is YouTube now a publisher? Is YouTube now a publisher? That goes back to the entire argument of whether or not they are technically going to be held liable for their actions because they are a publisher. YouTube has always been a publisher. That is legally, it doesn't change the conclusion. Up until 1996, the argument was if a website is considered a publisher, that it can be held liable for the content is being held upon. The Section 230 part of the Communication Decency Act removed that idea, and that basically said that now YouTube or any other platform at that point is not liable for the content of its users. That means it's not only not liable when we place content, it's also not liable when they then decide to act based on what we have done. So the issue then is whether or not they're a publisher or not, because they are in control of the advertisement, doesn't impact their liability here at all. Now, the issue then becomes, does Section 230 protect them when they are monetizing or demonetizing videos? And the answer would be, well, that's actually an interesting question. I don't want to jump to the answer. 230 immunizes platform from actions they take based on the content of their users. Now the question is, if YouTube is taking action based on the content of the comment, they can remove those comments and not be liable under Section 230, right? So they're definitely allowed to remove content. They're definitely allowed to terminate accounts associated with a comment and still protection. The question then becomes, if they are acting based on content, not of the content creator by a third party, and they then demonetized or removed the video, is Section 230 actually going to protect them? And that's highly questionable, because why would Section 230 protect a platform for damages it may cause a content creator when it's acting not based on the content produced by the content creator, but rather by a third party? So Section 230 wasn't designed for that. People didn't think about it. But again, remember here that what they are doing is they are brokering advertisement. They are not basically making decisions on whether or not your video is demonetized, as much as within the boundaries of the agreement. As a broker, they are actually fulfilling their agreement to you by placing some advertisements on through your channel. It doesn't guarantee anything else. You don't necessarily need to go to Section 230 to see that the agreement was designed for that. Now, they would argue that Section 230 still protects them because they are acting based on content of users, and 230 does not necessarily say that I'm only required to act based on that user's content. So it's quite possible Section 230 is broad enough that allows them to, let's say, even remove a video that otherwise perfectly permissible based on some third-party content, even though that content had nothing to do with the content creator because of the way Section 230 was actually written. So there's a potentially interesting legal question there. But my feeling is that the way the law is written and the way it's been analyzed to date makes it a very, very broadly interpreted statute, which will still protect the platforms. Milim, do you think it can go even further? If someone puts your video link into some questionable website, will YouTube demonetize the video because it is linked from that site? Oh, that's actually interesting. So as you know, you can actually use the same AdSense account to actually monetize your website or any page for that matter. So you can monetize the page and you can monetize content within it. So to the extent to which is something questionable on the page itself can actually be unmonetized, but so will the video itself. That's also written into I believe AdSense, that says that if your video is actually placed into an otherwise objectionable content, neither one would have to be monetized. Again, for two different reasons. The page is not going to be monetized because that's a complete violation of AdSense and their community guideline rules, but your video may be demonetized for a different reason under a different provision of the AdSense, basically saying, as a broker, I'm choosing where to place the advertisements, and I'm not punishing you by not placing as many advertisements. So the answer is yes, they could under that idea, even if you have nothing to do with it. Even if a third party then links them and puts it on their page, they can actually demonetize your video views through that page. Arguably not on YouTube itself, but on that page. Now, I'm not want to say that they can't. Arguably, they wouldn't do it on YouTube itself, but can they actually stop showing advertisement to anybody? Yes, they can decide, look, we have a finite amount of advertising dollars. We decide to only focus on tech review. because that's where the best rates are. So we don't want to waste a lot of money serving low-cost advertisements against other channel. They are perfectly permitted to do that because because they're acting as a broker, and nowhere are they guaranteeing you that a certain amount of money will be earned, a certain number of advertisements will be shown, the certain quality of the advertisements, or anything else. Somebody's mother, thank you so much for the super chat. New Zealand State Services Commission asked government department execs to suspend ads on YouTube. Government offices state TV has pulled ads because of comment controversy. That's fascinating. I didn't know that at all. I wonder what is the basis for them to do that. Now, again, contracts are read differently across different countries, and in some countries, when you have a contract, there are more obligations being placed through the contract than actually is what's in the paper itself. Sometimes there's a lot of provision that the law requires as part of the contract, the way parties deal and the way they interact. Things that simply do not exist in the United States, where, frankly, the rule is, unless there's an exception of illegality, whatever falls within the boundaries of the contract actually goes. Unconscionability being a questionable part of it, whether or not certain provisions are just too out of bounds when it comes to the law and they're not going to be enforced. But I didn't hear about that, and I'll be very interested if you can shoot me a DM on Twitter. Let me know if you can link to any sort of article I can read. That'd be great. I'll be very interested to see what is the basis within New Zealand to actually pull the advertisements. Layfan death. The obvious fair compromise would be for the cheap tards at Google to hire help, notify the creator there's a problem, and give them a chance to correct it, not penalize them up front. I couldn't agree with you more, but wouldn't you say that's true about everything? If there is a problem with content, wouldn't the best thing to do is say, you know what? Let's communicate immediately with the content creator. Give him, very short time to respond. There's rarely an emergency here, right? This is not stuff that lives depend on. This is just basic stuff, breaking some of the rules. Can we engage the content creator that is making us money that we're advertising against, see what changes could be made? A lot of this, you have to put copyright issues aside. They have to follow up and do it very, very quickly based on the way the law is written. But I'm with you. I think about with respect to everything, all the rules. Why don't you actually engage the content creator rather than penalize them and then ask him to appeal and create a convoluted appeal process? Why don't you actually engage them? Create a period of time through which you can engage the content creator, see if this can be resolved quickly and efficiently without actually punishing. I'm all with you. Blessed Inc. Also, in the guidelines of YouTube's terms of service, upon signing up, it states things are subject to change without notice. Absolutely true. That's true in every single terms of service. I told you that I've written just hundreds of this stuff for just about every company you can imagine, and I put it into every contract. It's just standard. Why? Because your client needs the ability to make changes down the line. You don't know how they're using it. You don't know if they'll use it for good or bad, but that provision is always in those terms of service. So true, but don't forget that there are no changes in the terms of service. They haven't actually placed a rule within the terms of service related to punishment based on the content of a comment. So they haven't actually pulled the trigger on that. They're basically announced for all practical purposes how things are done internally, which are not rules. And that's why they on the one hand, they can't use it to divert funds, meaning they can't use it to directly punish you by showing ads but not giving you the money, the way they were trying to do through the whole super chat controversy based on inappropriate comments in the super chat and where they were diverting. That's something that they're not even trying in this case because it would be completely impermissible. What they're doing is completely demonetizing or actually limiting advertisement to that video because that's still permitted as part of their role in brokering the advertisement. And frankly, it doesn't trigger some of the problem that diverting funds or suspending accounts or taking down videos will entail. And they don't have to actually change the rule to enable that. Nuvi, I've personally viewed videos that have advertisements on them, videos the YouTuber claims to have been demonetized. I can't verify, but it's true. What are the options there? That's an interesting one there, and that's what I was trying to explain, that if they have certain rules that are being violated by them, it's quite possible for a video that is still within the partner program and is still subject to AdSense. So it's still a monetized channel. But when a video or the YouTuber, for any reason, actually violates any sort of written rules, the way it is about things like about basically not necessarily a written rule, rules dealing with their own content. So whether or not it's written or something that they change over time, for them to then actually show advertisements but not share the revenue, because that's built into their agreement. The idea is that they can effectively advertise, show videos, show advertisements, collect money, but not share it with the advertiser because of a violation that he actually did. So we're not talking about violation of somebody in a comic, but the violation of the content creator. That's where you can get into a whole unconscionability. Whether or not in a contract of adhesion, which these are, where they are giving you a contract, you have no chance of actually negotiating, you are forced to do that. Whether or not they can actually enforce an agreement that says that we can actually advertise against your video, but not share any of the advertisement in a world where you gave a specific permission through AdSense to do that. The question then becomes, without AdSense, are they permitted to monetize your videos without sharing anything? That becomes that question, whether or not the minute you sign with AdSense, meaning before you have AdSense, they can show advertisement and not give you anything. But the minute you sign up to AdSense, it's subject to a license. And as a result, they can either show advertisement and give it to you or not show and not give it to you, but they're not allowed to show but not give it to you. So I'm agreeing with you that I've seen that take place, advertising that are not being shared with a content creator, but that might be subject to unconscionability, but hasn't been challenged yet in court. Bart Silverstein. Missing. Oh, here it is. Sorry. Bart Silverstein. I'd have the ads been blocked. How does that interplay with YouTube Red? Or even if the ads have been blocked, how does that interact with YouTuber Play? Generally, it doesn't. That's less of a legal issue, more of structural administrative. My understanding is that to the extent to which people come to your YouTube Red doesn't depend on advertisements. It basically, you are earning effectively a share of whatever the cost is every month that the YouTube Red, or now it's called Premium, subscriber pays. So it's $5, $10, or whatever it is. So that's not actually impacted by advertisement. So all of these arguments are all driven by advertisement, since they are the one who are paying. In this case, since it's the subscriber who pays, and it's not as if the subscriber is saying, I don't want to pay for an advertisement or to be placed next to this video, that money gets shared regardless. So YouTube Red, YouTube Premium, that pays out regardless of these rules. So that actually works very well for content creators. Garrett Claiborne, can you clarify sovereign immunity? For example, can one sue a congressional committee, or is only the executive branch vulnerable the way we see in the news? Generally, sovereign immunity carries to, and it kind of depends. And I can't tell you that it's my level of expertise, but into all municipalities. So it's not just in the federal level, it's in the state, it's in a, and it's So it's the state itself that is protected, and it's some of the individuals that work for the state, as long as they work within the boundaries of their job. The times you can actually sue them if they do something outside of their job. So somebody breaks the law, that is obviously not going to be covered by any sort of immunity provided to them as an employee of the government. So at that point, they're still exposed to liability, and that's usually the interplay between things, whether or not they did something within their job. So if you don't like somebody's policies or how they voted, you cannot sue them based on that. They're going to be immune. But to the extent to which they broke the law somehow, that's never going to be covered by any sort of immunity provision. That's something that they're going to be exposed to. Mazamanti, have you heard about Project Veritas and their exposure of Facebook's practices of deboosting channel? They use right-wing words in their thumbnails. I heard of it. I didn't really follow enough to make a comment on it, though in general, that doesn't sound very surprising because we've seen it elsewhere. So it's not surprising that Facebook would do it because you see it in other places. Bottom line, Facebook makes money off of advertising. They care where that money comes from, not as much about the content, but only to the extent to which that content makes them money. So I'm not surprised by it. I didn't really read it directly. I mean, I heard about it, but that should not surprise anybody. Derna, 1804, since the rules for publishers under DMCA don't apply to offline publishers, could it be struck down under the basis that it doesn't give all publishers equal rights under the law? Doesn't give them all. I mean, let's put it this way. The Supreme Court has already opined on it, and it's been broadly interpreted, and so it's about as uniform a reading across the federal circuit as you're going to have. So there's very little room here to say, well, suddenly it's unconstitutional. It's an interesting argument, but given how much scrutiny the DMCA has received, and not the DMCA here, Section 230, it's not really a DMCA, it's Section 230 of the Communication and Decency Act, how much scrutiny that they received, the likelihood of a federal court not coming back and saying it's unconstitutional is very, very small. Jacobson, we need community broadband and community access videos too. Only then we'll have the First Amendment protection. Till then, it's just a corporate policy and goodwill. So what you're referencing here is basically what we have in radio and television. The idea is that the public airways are owned by the public, and as part of licensing them out to private organization, they will make money off of it. One part of the negotiation is to make sure that those companies then actually secure public airways that are made available to people, basically public access TV and radio stuff. The difficulty with that argument is that while the airways have been determined to be public, the broadband is not. Those are lines that are actually being placed by private companies. As a result, the same kind of rules have not passed on to the internet. The closest you get to that kind of argument is through net neutrality, and I don't want to reopen this argument right now. There are definitely now a number of different proposals where net neutrality is, but we're not going to get public access because for that, the law has to determine that broadband is a public equivalent to a public airways, which it's not, because it's not carried by the air, it's carried by lines being placed by private companies. So there's your argument. That's a difficulty in that argument. Somebody's mother. Most companies here in New Zealand have also pulled ads on YouTube because of the comment section of YouTube. This has all been in the news for weeks now. Right, so we definitely saw companies pull their ads. It was one of the things. This did not start when a mother asked that question. This was asked because of a YouTuber. People have done YouTube videos on it. I don't remember his name or YouTube channel, that started creating a lot of almost spammy videos about this idea. Somehow the YouTube is doing something wrong because it needs to look into the comment he created this kind of brouhaha that got picked up by the media and eventually by advertisers that says we don't want to put an advertisement next to a video with that comment. YouTube cannot do anything about it. An advertiser can pull their advertisement at any time. So yes, absolutely that happened. YouTube was responding to advertisers pulling out, being worried that they're going to face another apocalypse kind of situation. They wanted to shut it down. And so the first thing they do is demonetize based on content. My problem is if they can so easily determine what those content are, they could have dealt with the content of the of the comment all along. They always had that capability. They chose not to. So YouTube is not innocent in it. It obviously chose not to do that. But the question then becomes, can they? And that's really the argument here, is that yes, they were reacting, and yes, as long as they actually are showing, as long as they are not showing any advertisement, they are able to then demonetize a specific video because of their role as a broker. Cap Strong, thank you so much for this super chat. Do you watch the Joe Rogan Jack Dorsey round 2 live stream this evening? Oh, did you watch? I did not watch that yet. I watched obviously the first one, which was kind of useless, but I will absolutely watch. I didn't know it actually happening this evening. It seems that every single time I do a live stream, something big happens, like the president speaking or some member. I think that was when Peterson and Rubin did a live stream pulling out of Patreon. Now Joe happens, I guess it's for some obscure reason, Tuesday evening seems to be a good time, but I will definitely catch on with it. Thank you so much. Somebody's mother, you can read about it in the New Zealand Herald. It's all based around the timestamp pedophile comments in the children's videos. Yep. Millim, is there a problem with ads on ads? Sometimes when I click on the ad video, it redirects me to the original ad video and puts another ad on top of it pointing to another advertisement. Ah, wow. I never tried that. That's interesting. If under the licensing they're allowed, if you click on an advertisement, to take you outside of that, as opposed to it will depend what they do with your video. If they completely transfer you to an advertisement video, that probably be problematic. But to the extent to which they open up another window and pause your video, that's probably permissible. At which point there's no real reason why an advertisement cannot be placed on top of an advertisement. I know that content creators can do it. So, talking about what happened prior, there are some problems associated with you actually setting up a web page, monetizing the ad page, meaning placing AdSense on it, and then inserting a video that also has AdSense. Typically, YouTube demonetizes the video. It doesn't allow advertisement to be earned on both things, which seems unfair because, well, if it's your own video, that makes sense. You shouldn't be able to make money on the page and on the video itself because you're actually getting two things at once off of the same event. But that I believe what happens is that the video, even if somebody else's video effectively gets demonetized, when the page itself is monetized. I think that's the case. Somebody's mother, thank you so much for the super chat. Do you think that YouTube knee-jerk reactions are a response to the upcoming Article 13 and the liability they might face under the new European laws? I think that they're very worried about it. I don't think these kind of actions. I think that no matter what, we just spoke about Facebook, YouTube is concerned about one thing, which is where the money comes from. Content creators are secondary. I think in their mind, there will always be people that are willing to create content, and if not, they are going to bring in large media content, right? Movies and shows that are created by large media companies. Their big concern is, how do I bring in money? How do I keep the advertisers happy here? And that's where they're reacting to it. They are very, very concerned about content created by small YouTubers because they cannot control them. They don't have any sort of history. They don't know what is being produced. They don't know if these people are abiding by some sort of a rule or a standard. When they're talking to a large media company, there are far higher standards those media companies have to adhere to. The concern of YouTube is far more minimized. And so this is more concerned about where the money comes from. It's not as much about Article 13, at least not in this case. Brian Fediuk, I think that's. Do you think large YouTube channel would weaponize this comment controversy to prevent smaller content creators from stealing their thunder, remove monetization, kill the channel quality? Oh my God. Anything is possible. Without mentioning name, we've seen relatively large YouTubers act in a very, very small way, filing DMCAs against people, filing false complaints with YouTube, claiming not only DMCAs but harassment and racist content and stuff like that, all because they felt that whatever was being said against them was somehow hurting them, so they were effectively weaponizing it. I'm not sure if this is a tactic that where a large YouTuber wants to kill off competition, as much as these are just small-minded people that feel entitled to do whatever they're doing. So I would guarantee you this, if it hasn't happened so far, it will happen, because we've seen terrible behavior by people that have already reached a modicum of success on YouTube, actually deploying the very thing they complained about, which is false flagging other people or taking down video based on illegitimate claims of copyright infringement. So I suspect it will happen. Unicorn Sprinkles, don't forget to click like. Thank you so much. That would be a big help to the channel. Serafina, what about mobile data? Last I checked, cell phones are still public airways. Yes, I have to admit I kind of ignored that subject, because that is, but when you look at the way case law has happened, it kind of throws that into the same argument as broadband. Why has that not been separated? Why has the government, which actually licenses out the airways for a mobile platform, why have they actually not said, you know what, to the extent to which data is being transmitted, shouldn't there be public access airwaves as well, where people are free to do that? I think that makes absolute sense. Again, they couldn't do it in broadband to your house, but they should be able to do that when it comes to mobile broadband, which is frankly the more interesting, more powerful, and with the expansion of 5G and all, that's where we're headed anyway. So that's an interesting argument, an interesting discussion. I'd have to check on it, but it's something I thought of in the past, just haven't really looked at it too far of why. But I can tell you that when the legal arguments are made, mobile is just being thrown in together with broadband, even when it comes to net neutrality, without any arguments about rights of access. So for some reason, everybody's ignoring it. Not clear why it is. I'd have to check. In fact, that's actually a pretty interesting argument. Now it's going to bother me, so I'm going to check it myself. Thank you. The real Bill Nye. This is kind of off topic, but why is that free speech doesn't apply to the private sector? I hear people say it all the time like a mantra, but I've never heard a professional reason. There is no reason why it doesn't apply to the private sector, except the Constitution only guarantees it as a right by referencing the government. There is this argument that a number of the things, if not all of the things within the Bill of Rights, are inherently individual human rights. It is not that it's granted by the government, it's a recognition there are certain rights that each human being has, at least while within the boundaries of the United States, and the Constitution recognizes it. So speech is not granted, free speech is not granted by the government with respect to it, but rather recognized as a right that the individual has. Same with assembly, religion, even right to bear arms, depending how you read it all. So there is no logic to say that free speech is, if you would have to argue that free speech is a basic human right, and the fact that the Constitution doesn't guarantee it doesn't actually negate it. But the reason why it's not been legally extended to the private sector is because we have a constitution, and a constitution basically says free speech is a principle vis-a-vis the government, and the way the laws have been interpreted, that it's only a basic human rights vis-a-vis the government acknowledged by the constitution. So that's where the argument would be. You would have to make a legal argument that free speech is a basic human right, and it doesn't have to be recognized by the constitution to be valid. Or you would create, this is kind of off topic, in the United States, we don't have a clear set of privacy laws on a federal level. We just don't. The concept of privacy was first created by Justice Brandeis. He wrote it, and I forgot, he co-wrote it with somebody else. I forgot the name of the co-writer. Also somebody of great legal career, a great legal mind, but I forgot the name. But anyway, he wrote this before he was a Supreme Court justice, explaining that privacy is this zone that's created by multiple areas of the Constitution. That if you look at all these different laws, it creates a zone, effectively, that we call privacy. That idea then eventually gets carried on. He becomes a Supreme Court justice, and that's basically the basis of privacy rights in the United States. You could argue that even though the Constitution doesn't necessarily indicate that rights of free speech is a basic human right, regardless of who it is vis-a-vis. It's also vis-a-vis private individual, vis-a-vis private corporations. We have a right to speak, and you would have to actually look at the entire Constitution to say that we have recognitions of basic rights that are not necessarily enumerated in it. It would take somebody of a caliber like a Justice Brandeis to come up with that kind of a formula and actually convince the Supreme Court over time that that's a valid argument. But that's basically what you're asking for, a recognition of a basic human rights. But right now, it's not in the Constitution. Alan D1. If a channel is demonetized, can YouTube still put commercials on the video? If so, are they required to pay the channel? Right, so that goes back to some of the prior argument. If the channel is not subject to the partner program or to AdSense, meaning it's not monetized, YouTube, I believe, as the platform owner through a license, can still monetize those videos for its own sake and not share anything. The minute they allow you to sign into the partners program through YouTube, they are required to share it. The argument then becomes, well, if you violate a rule and they then demonetize you, can they run it and not share it with you? According to their policies, the answer is yes. They write it specifically that they are permitted to collect money and not share those funds with you at all. The argument there is whether or not it's unconscionable, whether or not, even though it's a provision in a contract, whether or not a court would actually honor that, or say that's just unconscionable. The very idea that you can demonetize somebody and do it, you would do it all the time because you can just collect more and more money. That kind of a provision would never be conscionable, should never be actually enforced by the court. But like I said before, that has never been challenged, so we don't know. But to me, it seems like that kind of a provision, when done, is unconscionable. Beach Geek. Wouldn't wireless and wired broadband be the same? In both cases, a company leases property, airways, or the right-of-way to build their infrastructure. Okay, so when you are getting a license for TV and radio, the idea you're licensing the public airways. You can make the same argument for mobile data because it's all about airways. In many ways, these are just competing frequencies. Broadband, this is your own property, but you are effectively gaining a right of way, let's say underground, right, or through poles or however it's being delivered. But since that is not going to be owned by the federal government is not going to be including any provision, and the states or the local municipality, they're free to negotiate whatever they want to. In fact, they have. Normally what happens is if a broadband company wants to tear up the streets to go to the city says, yeah, what am I getting in return? They're going to get something in return. Either they're going to get some discounted rates so the city itself can enjoy some of the facilities at a discounted rate. They might get free access to a government TV station or broadband, basically saying, we have it in our own city. Basically, they lay down the pipe, and then the government gets to broadcast its own. This is not a public access, meaning not available to you and me, but the government, the local municipality, negotiated that for their own behalf. So it's possible, but then you're dealing really in localities. Before we're dealing the federal government saying this is the public airways, we are allowed to negotiate that, which is questionable why they haven't negotiated with respect to mobile data. But when it comes to lines, that really is more of a state and municipal and city action. The federal government doesn't generally have a say in any in licensing, or really not licensing, in getting access to the underground facilities. Darna 1804. Do you suppose Google doesn't necessarily care about YouTube's ad scheme being profitable? Can they legally harvest data from YouTube to add profit to Google while YouTube loses money? Well, that could be it. Yes. There's no doubt that there is enormous amount of data accumulated through YouTube. I have no doubt that 100% of all that data is being shared with Google at large and used to make money by selling advertisements. I just can't imagine they don't care. Look, YouTube doesn't have to be profitable for Google to care about it, because they make money off of information, and every time something is uploaded, every time somebody watches it, every time somebody comments, information is being gathered that can be used to advertise. But I can only think that Google cares about advertisement against YouTube the same way it cares about it against their search engine or against any property where they can advertise. It's a place to make money. So I don't think that they would intentionally demonetize and reduce profits for the sake of data. I think that what happens is that let's say there's $1,000 worth of advertisement that's going to go into YouTube. When Google demonetizes a section of YouTube, Google doesn't lose any money. That money then goes into a smaller basket, which then raises the rates, which means each video that is not otherwise excluded makes more money. But Google basically enjoys the higher rates because there is less supply, the same amount of demand, but subject to less supply. So I think that's what happened. It's not losing any money when it demonetizes channel. It, in fact, can more than benefit from it, because if you follow economic theory, prices should go up because there's less supply of content, the same money being dropped into it. So at the very least, they're making the same amount of money. More likely than not, they're making more because their rates would then go if they demonetize at least a significant number of channels. 10-hour loop. Hello, how are you doing today? I'm doing very, very well. Thank you so much. I really appreciate it. I think we are reaching that point where we're going to finish soon. I see there's another quick comment here. Serafina S. The cable laying part is just utility easement purchase, isn't it? Exactly. So, but that's going to be local. That's going to be something that's going to own by the state, by the municipality. Yes, there's some federal land where you're going to get an easement on, but that's not significant enough generally. Although it could be, and I don't know how the layout of the land in the United States is, whether or not ultimately to get from place to place, most of those companies, at least the large national companies, have to go through federal land, at which point the federal government can actually add that kind of a requirement that public access be provided. So I don't know the layout of the land enough to say that, but it's definitely those last miles. It's where it's important, and that's where they are contracting with the state, with the county, with the city. the village, depending what it's in. If there, against Serafina, if there was any tool they could try with fixed line, it would be their communication provider license, maybe. You're saying to the extent to which they are running certain communications through their fixed line, the government might be able to still extract certain rights from them beyond just a licensing fee. Arguable, that they could do that. Why the government has not said, you know what, let's secure public access as a way of dealing with that, so that every company, whether or not it's licensing anything from the federal government, whether or not it's laying pipes and seeking an easement, and we can now actually tack onto it some public access requirements, or through mobile or broadband or anything else, why can't they take on public access requirement? I don't know. I haven't looked into enough to give you an answer. It's a very interesting idea. I'm not sure if people thought of it or not. Maybe it's kind of maybe people just have not thought about it. They're used to dealing with TV and radio and seeing that as a common thing, just haven't seen it outside of that platform, and so I have not thought about it. It's an interesting idea. Art Silverstein. If your supply and demand is right, wouldn't it be a conflict for Google to demonetize as many channels as possible? It would be a conflict of interest for them. The question would not, at that point, it would be illegal. Yeah, I mean, look. You could argue that the more channels, the more content that's being created, and the more, let's say there's a constant to advertisement. It's obviously not true, right? I'm assuming that advertisements over time grow. But let's say that for a given dollar of advertisements, if content is constantly growing and it's being spread across the entire base, that means that on average, the rate of advertisement is going to fall over time. Now, should Google say, you know what, I'm concerned about the low rates, and I'd rather have it higher rates at playing against channel that keep people longer, and as a result I like to demonetize more and more channel. You could argue that's what they did when they changed the rules, right? When is it? Sometime in 2018, that says we're and I don't remember what the original rule. I think the original rule was, if you have over 1,000 subscribers, you can get monetized, and they changed it to say 1,000 plus 4,000 hours of videos, something like that, and effectively demonetizing an entire segment of their base. That's what they did. You could argue they did that and it benefited them. They would argue that it's for the benefit of the community at large, but that's effectively what they did. When they say that smaller and smaller channel cannot monetize, they basically are trying to constrain where advertisement dollars are going. So yes, there would be a conflict of interest. The question is, are they not permitted to run it that way? And my argument is that they actually are permitted, because the way they've drafted the agreement and they've set themselves up as a broker, they are not required to deliver advertisements to you at any rate. So they can actually keep you monetized, but not deliver as much advertisements to you in order to control the rate of advertisement. So, how much any advertisement is showing, and then saying, we're going to redirect that to specific kind of channels that we believe are going to keep the rate higher than normal, because that's how we're going to compete. Because ultimately advertisers want to get as much out of the advertisement as possible. It's quite possible for us to control that basket so that not only is the advertiser happy because we are not showing it against, smaller and smaller channel that can potentially be a problem. At the same time, we are keeping rates up, so we are happier than that. So it allows them to manage their advertising inventory better. I think that they're doing it already. Serafina. At least here in the UK, when we sell leased lines to our customer, we just buy the rights from the council. pretty sure it's an easement under the law through legal handles this usually. It is just well, the line is not. The line is private, but you have to acquire an easement in the ground where you're placing it to allow you to do that. Again, most of that is just local in nature, so you're not going to be able to get much from that. Razul. I don't have a question, but thank you for the informative content about tech law, and good luck with the fight with Patreon. Thank you so much. I really, really appreciate a lot of people working very, very hard on this project. It's going to bear fruit. Bart Silverstein. Demonetized. Darn autocorrect. Fred Leggett. Not a question, just wishing you well on the Patreon lawsuit. Really well. Thank you so much. Like I said, a lot of people, it is something that consumes a great deal of time, and I can't tell you how proud I am to be part of this group of people that are so dedicated. It really is a real honor to work with all these people. So we're pushing hard to get it out. Just, you know, it's definitely a massive project, probably more than I thought originally. So it's just taking a little longer than no, right now it's only been a month. It's not taking a little longer. When you live in that world and it's every single day, it seems to you like it's taking long, but in fact, it's just been a month. So it's not been that long, but we're pushing hard to get it out as quickly as possible. So I think you're going to see some results very, very quickly here. Fred Leggett. I lied. I did have a question. Has Subscribestar become stable? I can't, obviously, I don't have any information about their relationship with their own payment provider because I don't know enough about it. I knew about it because I spoke to them when they were getting that facility. So, but so far it's working. I can tell you that I'm on Subscribestar and I have no complaint. Well, I can't say I have no complaint. It's working, and I'm happy with it. People are paying in, and I can take money out, so there is no real concern there. Doesn't mean that whoever they're using can down the line develop the same ideas as PayPal and Patreon and Stripe and basically kill off the payment facility. But so far, everything seems to be working well. Chris Stout. Here's how the New Zealand government department were convinced to stop advertising on YouTube. 1. The media called the marketing director for the tax department and threatened bad press. 2. The IRD can't afford to give people excuses to avoid taxes, so they folded. The rest of the department folded immediately after because of the precedent. It seems that, especially when it comes to large organizations, I guess the government is not immune to it. The fear of bad publicity drives them to act in ways that otherwise, if you took time, you probably wouldn't act. Thank you so much. I think we're done for now. I think we are, right, we're about an hour and 20 minutes into it. My throat is getting a little dry, so I think I'm going to end it here. Thank you so much for showing up, guys. I really, really appreciate it. I enjoy these conversations with you. If you have any ideas about any particular live stream you want me to do, a specific topic you want a video on, shoot me on DM on Twitter. I read all of it, even if I'm sometimes not responding. I'm always reading it. I try to respond to everybody, but it becomes overwhelming sometimes. But I'm always looking for ideas, new thoughts, anything on gaming, anything about our digital world. Always great topics. If you have any questions, any concerns, anything you want to discuss, leave them down below. I'll love to talk to you. I'll see you next time.